Okay, good morning, everyone.
Good morning, sir.
Good morning, sir.
How are you? Hope you had a great week. You didn't have a great week?
Yes, sir.
Good morning, sir.
Good
You're
morning.
tired.
How are you? Now, we are going to, I see that there are about 48 of you that are online right now. So what we're going to do is start off with a small recap of what we did last, that was on Monday, so that we can go through any little thing that you do not understand. So can somebody just give us a small recap of parts of what we did earlier in the week? Hello? Henry Bekwe.
Yes, sir.
Can you give us a small recap of what we did? Doesn't have to be the whole thing, just segments of it. Whatever you can remember.
Okay, sir. Last week we talked about the distinctions between law and morality, and okay, let me just talk on let me just talk on the nature of law.
Go on.
Discussed last week. So we said that the nature of law was at first conceptualized by Plato and Aristotle.
I can swear you are reading the slide directly.
They seem to
it's not the problem really, because that's the nature of what we are studying. So it's not this thing, but the key thing really is, number one, for what we did last week, like I said, it's important for you to know the components of what we were doing and what the objectives were. Number one, we talked basically about the nature of law, and I told you the reason we're talking about the nature of law was to set a stage for beginning to learn about the schools of law. And if you are beginning to understand what the schools of law is, then you become more, your aptitude is a little higher if you had done what the general nature of law is. And we talked about, you had done certain concepts already earlier in the semester. You've done things relating to possession, ownership. You've done things relating to personality and all that. And you also did things relating to nature of law last semester. So what we did for our first lecture earlier in the week, basically, was just to serve as a recap, a reminder of what you had done, and then for you to start having some kind of idea relating to what law is, how you perceive law. And the first thing any jurisprudence scholar will tell you is there isn't a yes or no answer to anything. The question is always, what is the purpose? How did you arrive at what your deductions? What kind of evidence? What kind of arguments did you make? What kind of evidence did you look at? And then we talked about jurisprudence as basically, so that you understand your place in what we are doing. Jurisprudence as something that is the foundation for laws because of its because you need to have a philosophy, you need to have a general idea as to why you have law, whether you are using it as just a social control tool. If it's just a social control tool, is that good enough? Especially for citizens or states that come from developing countries. How do you interpret law? Do you interpret law in line with your needs as a nation? Or do you just interpret it in a random manner because you do not have a philosophy? When people have philosophies to anything, their behavior is more organized because everything he says has to touch on the particular philosophy that he believes in. That's why in the US, for example, if somebody is being nominated for, say, the Supreme Court by the president, already you have newspapers writing extensively about that person, about what he believes in, about how he interprets statutes, right from the time he was a district court, right up to the time of the nomination. Why? Because that person has a philosophy. He has a philosophy of things. Am I a conservative interpreter? Am I a strict interpreter? Am I a liberal interpreter? Do I have a purposive approach to interpretation? So all those things come into play. And for each and every judge you find in most jurisdictions, there's a trend in terms of how he's going to interpret one thing or the other, because interpretation cannot be done in vacuum. It is done within context. And what you believe in can be part of the reason you interpret things in a particular manner. And that is what we want you people to do as students, to start evolving some kind of philosophy. Not just about law, some kind of philosophy probably about life, about what you are as a man, what you are as a woman. When you say you want to work, what are you working for? Why are you working? You know, and then we, in our idea of law, we came with three basic things. One being the nature of law, which was what we did extensively, the nature of law. And again, like I said, as with any other thing, it's the nature of things, not just law, the nature of you, who you are. If you are going to get married, for example, the nature of marriage, what is marriage? What are the nature? What are the components? And when you use this kind of components to answer those kinds of questions, then you find it easier to be able to reach your objectives and whatever it is that you want to use that theory, that philosophy for at any particular point in time. Then when we talk about nature, we said too, you also talk about application. How do you apply things? You study things, infrastructures and whatever. If you talk about the marriage, for example, is a house integral to, is having a home that you live in with your wife and your children in future, is it integral to being able to be in a marriage? So you look at things like that in terms of infrastructure and all that stuff. Then at the end of the day, you look at the eternal purpose. What is the final purpose of this thing I want to do? When I got into my car this morning, the eternal purpose was to make sure that nobody hits me on the road before I get to my office. And to apply that, I had to be careful, use my car well, use myself well in terms of how I drove and all that stuff, just to get to the office, because that was the end goal for that particular event. And in a way, when you study law, it's also similar, because the eternal purpose of law should be, what are we trying to do? Are we trying to control? Are we trying to develop as a nation, as a state? And then your laws and every other ancillary things, such as interpretation of laws and all that, will follow the same path in an organized, structured manner. I hope we understand that.
Yes, sir.
Okay, so Ibekwe, thank you very much. You said the stage, and I want to specifically thank Priscilla Badewa, because you are the first person in the class today, and I like people to be quick. So thank you for opening the class for us. Now, part of the things we are going to learn today, and we'll still be casting our minds back to some of the things we did last week, because we have to keep understanding in terms of what our duties are as students and as citizens. Now, we talked about some of the things, and we said, okay, law can be an ideology. Law can be a legacy that is passed down from generation to generation, the study of jurisprudence, okay? And then you can also use it as purpose for specific things. And then we talked about Samuel and Duncanson's thesis of how you can use theories. And we looked at theories and we said theories are not necessarily a kind of a theory fits all, an answer to all the questions. And we used the imagery of a mirror to say, if, for example, you are using a mirror, there are different purposes you can use a mirror for. In the same manner, it is the same thing you do with theories. What are theories? What can you use this particular theory for? And we said for the positivists, for example, because of their reliance on the power of legislation, on the power of things like command, to be able to command, have authority, their work was very specific in terms of our understanding of legislation. Then if, for example, you look at theories emerging from the sociological school, again, their work was important in terms of how we learn, in terms of how we see law, not as a vacuous separate thing from other things, but as just one of social control mechanisms that are in place. And that there are other things outside of law that also affect law. And then when you look at that, some of these things may appear vague when you are discussing it, but they are not vague in actual practice because, and I'll give you an example. When we started our legal aid clinic at the faculty, it was in furtherance of how sociological scholars thought law should be studied. That law shouldn't be studied in theory where you come out and then you are just beginning to learn practice. That there should be a study that is clinical in nature, the same way medical students, when medical students come out of medical school, bam, they're ready to go. Of course, they start with little things. Maybe he can take care of things like malaria and things like that. But the problem we had in law was we didn't have that process. So because of that, it becomes very easy for you to see what the sociological school was trying to do, even in terms of interpretation of statutes, when they talked about context. We'll go into some argument that they came out in terms of if you're interpreting a statute strictly, what are the problems, the pitfalls that you meet? Whereas if you're interpreting it in a liberal manner, what are the pitfalls again that you meet? But even if you do not meet any pitfalls, what are the objectives for interpreting law and things like that? So we'll go through all that. Now, the idea is to set a stage for you to understand the schools of law. And when you set a stage to understand the schools of law, we also talked about, I think one of you, Kwajafa, I had this discussion and I said, some of you will probably be thinking now that, what trouble did I put myself into in jurisprudence and all that stuff? And we discussed, and I said there were 2 books that I was introduced to, and they turned out to be very educative in terms of how you proceed in certain things, and it applied to law, especially the studying of jurisprudence. And one of the key things that we said was the 2 books, The Outlier, and the second one is Mindset. And for those 2 books, one of the things, because these people were researchers who worked with children and worked with people right up to adult age, and they said one of the things that make people in fact fail is fear of failure. Why? Because you are constantly calculating things in terms of success or failure. So when you calculate things in terms of success or failure, you place a burden over your head in terms of whether you succeed or you do not succeed. So sometimes you cut corners to try to succeed. What you are supposed to read, you don't read. what you are not supposed to read, you try to read and summarize and do all that. So you don't really have the true knowledge of it. Why? Because you are looking at it in terms of you're already creating excuses for yourself. Now, if you have the mindset of somebody who is, and it's not just as a student, it's in life. If you have the mindset of someone who wants to be successful at what they do, then you don't look at it in terms of, am I going to fail or am I going to pass? You just look at it as a challenge before you that can allow you to gain knowledge. And that is when you start loving what you are doing, because your mind is now open. You are just thinking in terms of the knowledge that you are gaining. And those are the people that succeed and are the best students. Why? Because I tell this to my 12-year-old son. When I ask him if he were with us now, and I asked him, I just said, who are the people that win the race? My 12-year-old son will answer, he will tell you, the people who just love to run. I hope we understand.
Yes, sir.
Yes, sir.
So if you love to run, you get better at it, at running, because you love it. And the way to, it's like a chicken and egg thing. As you get better at it, you love it more. So you run more. Then you get even better. Okay? So don't get into this mindset of, I'm trying to just pass my exams and get out. A lot of the knowledge we also pass down to you were knowledge that we got in secondary school at the university level. And this is knowledge that will be absolutely important for you. So having set that down, let us move to our, okay. Now let's move to our class for today. Today, we said we were going to start with the positivists, who are also known as analytical jurists. Please, anybody can interrupt me at any point to ask a question, to ask for where I can either answer you. If I'm too confused to answer you, then we can have that discussion among each other. I hope that's okay.
Okay, sir.
Great. Now, we said the schools of jurisprudence are many. I'll be taking you some. Mrs. Raji will take you, I think, about 3 of the schools. She will be taking you the Maliki School of Law, take you feminism, and take you African jurisprudence. But in the process, we can always discuss all these, and then I'll also send you some sources even relating to some of those ones. Now, the Positivist School, let me give you a historical background of the schools so that you know each time you are reading or learning about the schools, you understand that. The first known school was the natural law school. And the natural law sentiments were brought about by people such as Plato, Aristotle, and all that before you started having people like the more recent scholars like Thomas Locke and Jean-Jacques Rousseau and people like that. Now, and Thomas Hobbes. Now, one of the things that you always have to keep in mind is this. It is not sacrosanct that because one person is a natural law scholar, he cannot be a scholar of another school. Why? Because these are theories. That was why we were talking about purpose. Somebody can be a scholar of the Positivist School and he can be a realist at the same time. Why? Because there are aspects of the Positivist School that he can believe in and propound theories on that can make him a member of the Positivist School. And there will be aspects of the Realist School that he can also propound theories on that he will be cited as being a member of the Realist School. I hope we understand that.
Yes, sir.
Yes, sir.
Okay, so you are not necessarily tied to one school. You can have different schools in terms of different things. In some things, I'm a positivist. In some things, I'm a sociological scholar. In some things, in fact, my general idea of law, particularly in the Nigerian state, for me, I'm becoming more of somebody that believes in critical legal studies movement. Basically, because I look at I'm starting to think the purpose of law is not just there's a subjugative purpose for law, especially in our own in our own jurisdiction. But there are also some things that I see, and I think I'm a sociological scholar, there are some things that now when you start understanding the schools of jurisprudence, the moment something appears in front of you, you'll be able to link it, you'll be able to link your resolution of it, what you believe in, to a particular school's attitude. That is when you start to think, yes, I'm beginning to understand this. So there isn't any specific school people belong to. It's a question of purpose, a question of objective. What are we learning here? Now, there are a lot of positivists. Some of them, the three main ones that we'll be talking about will be Jeremy Bentham, John Austin, and Hans Kelson. But there are also some that came after that generation of scholars. We have people like H.L.A. Hart, who basically did a lot of work in terms of analytical jurisprudence. Then you have someone who is still one of the few scholars that are still alive, that are still quoted extensively, people like Joseph Raz. I think he's still alive as I speak with you. And he also was a positivist. But there are little differences in terms of what they believed in, even though the main theme of their belief runs constant. Now, Jeremy Bentham is one of the analytical scholars, and he was basically thought of as one of the fathers of the Positivist School in terms of how he popularized positivism with his theories. Now, I don't know, there are two ways to do it. I can either just discuss with you lightly, but because I want us to stay close to the slides so that we can answer, so that we can discuss specifically to it, and then we can answer questions that may agitate anybody's mind. So what we are going to do is try to stay as close to the slides as we can. Now, we've already talked, a lot of people talked about Jeremy Bentham, and they said he narrowed down law to its form and not its content. And that is a criticism you see that runs through the whole gamut of positivist scholars. The whole idea that they believed in the form of law. And how do you believe in the form of law? When, for example, you say law is anything the legislature enacts, which is what Jeremy Bentham said. Law is anything the legislature enacts. Who can make a comment on that? Because we are here trying to
Sir, I feel like
analyze.
Because like if the legislature did not enact the law, it won't become a law in the society, because they are the one that sets the law, and then we follow the law. They are the one that say, okay, this is a crime, and then this is the punishment for it. So without the law being enacted by them, it won't be a law.
Send it to us possibly.
Okay, now who is the second person that spoke? Is that Mr. Ku?
Sir.
Okay, go on.
I feel like
Abdul Hakim, Abdul Karim, Abdul Razak, go on.
All right, sir. The definitions given to the law by Jeremy Bentham simply means that before you can say a law is a law, it must have passed through the legislative processes and it must pass through all the requirement stage of law. What we can term to be a law is what the legislature said it is the law, even if it is not the law in their own intention. I mean, they make any declaration that is not actually, they don't intend it to be a law. But if they say it is a law, whatever comes from their means is regarded as a law based on the definition.
Okay, thank you very much. Now, why what you just said is fantastic for this discussion is that it takes us back to the issue of law and morality, and that there are other things too that other schools and other scholars may look at as being law. customary law, for example, can be seen as being law. The importance of international law, for example, is the international law is it just diplomacy and international relations? You know, and all that comes from your understanding of what you call law. Once you set, there's a matrix for everything. Now, once you set the indicators, a law must be a law must be B, a law must be C, a law must be D, then the issue of things that don't have a checklist of all those indicators, can you call them law or not? Of course, in your theorization, it will be difficult for you to call them law if you have a checklist that says a law must be so, and so, and then that checklist isn't complete, which is where you have other people come in and say things like customary law is law, that in fact, customary law is even a more efficient law than legislation. But customary law is not enacted by the legislature. If anything, what they do with customary law sometimes is to try to codify centuries after the custom has been in place, which is really like a recognition rather than anything else. I hope we understand that. So when someone, for example, says law is anything the legislature enacts, people see it as your focus is on form, which is there's paper, there's a statute, there's an enactment. The signature of the governor or the president is at the back of the statute. It was assented to on so and so day, like you talked about the processes. But the question, the bigger question is, just because those processes are there, is it law? So why is a legislation, for example, like, you know, I'll give you another example that we talked about earlier in the week. Why is a legislation like the Ondo State bush burning edict that we talked about? Why is it considered law while and nobody's following it? And then customary laws related to what is a marriage and how you conduct a proper marriage, which everybody follows, is not seen as being law because it is not enacted by the legislature. So you look at that, but don't let's go too far. Now, a lot of people also say part of these things that law a lot of times is a reflection of people's individual opinion. And that basically relates to how laws are interpreted. If you interpret law, you can have about 3 judges interpreting the same statute and they will interpret it differently. So it becomes the law emanating from the legislature, but it is punished by individual opinion rather than any specific scientific meaning. Now, again, people said he didn't talk, we've talked about this, that he did not take into mind the dynamics of the society in the obedience of laws. When commitments and we'll come to this, when commitment and obedience to a law was what made it law. Now, people like Jeremy Bentham and John Austin were not, and Hans Kelson were not as interested in whether people obeyed the law or not. They look at it in a formalistic manner, which is the fact that people do not obey the law goes to no issue. Once the law emanates from the proper authority that it is supposed to emanate from, it becomes law. Whether you agree with it, no problem. Whether you do not agree, it goes to no issue. That is not an inquiry that they think is worth taking. And Hans Kelson, for example, only looked at it from the perspective of, well, if it's an inquiry that can be worth taking for law reform purposes. I hope we're still together. Are we still together? I'm sorry, my network went off. Can you hear me?
Okay, sir. Yes, sir.
Okay, so I'll put back the presentation on so that we can take a look at it. So what I was saying was, now, if you are looking at things like customary law and all that, and someone is saying people obey customary law more than they obey regular legislation. So if you are saying somebody is too formalistic, what you are saying is, why should a legislation be seen as law? Nobody follows it. And then customary law that everybody follows. Why? Because it doesn't go through the whole checklist of what a law must contain. You look at customary law and then you tell yourself there's something wrong about customary law. It's not really law. Why? Because it doesn't emanate from a specific legal authority. Now, and I said we will go into all that. So I'm trying to make sure that, okay. So the most important thing for all this is also to understand that this, a lot of times, like we said, law is made up of individual opinions. Why? Because laws do not stop at legislation. It goes to the courts for interpretation. And a lot of times, law can be the personal opinion of the judge hearing the particular case. Like we said, you can have up to 3 judges with 3 different interpretations to a specific statute. Now, his censorial jurisprudence led him to a 2-pronged analysis of the is and the ought of law, which is where all this discussion we're going, is what we're going. Now, censorial basically will emanate from the word censor. When you're looking at authority, things like authority, things like sanctions and all that, which is, you can do this, you cannot do that. That is basically what it is based on. And it says the formal way to do things and what we should be concerned with is the is of law and not the ought of law. That when you are talking about the ought of law, that is a discussion without merit. You can discuss it in sociology, you can discuss it in other pursuits, but those are not the things that the legal scholar should be concerned with. What the legal scholar should be concerned with is the is of law. What is the law right now? What does it say? What does it say in the statutes? I hope you understand.
Yes, sir.
Yes, sir.
Okay,
Yes,
and
sir.
now his only relationship with the ought of law is in terms of when you are talking about legal reform. His only concern is at looking at the ought of law is if you are talking about legal reforms, then you are talking about legal reforms in the sense that you want to change the law. But ought must never question the is. Why? Because as long as it remains ought, it is not law. So why people have all these, obviously, time that we have a law reform process in Nigeria, you have sittings, you have drafts, they go through public sittings, they go through the lower house who look at it, send it to the upper house, and all those processes. Obviously, what is the ought of law is essential for all those processes. But those processes are not law, according to Jeremy Bentham. They become, what we are focused on is the is of law. That's another process entirely. And we said his treatise came to be known as the principle of utility. Now, the principle of utility, I told you that no scholar is tied to one particular school. It depends on your theories and the basic theme of your theory and which school it touches. For a lot of writers, they also see Jeremy Bentham as a sociological scholar and a realist. Why? Because of certain things, basically because of this principle of utility, which cuts across those 2 or 3 schools. Now, we said this is thinking came to be known as the principle of utility. There are also other names for it, like hedonistic calculus, or the principle of pleasure and pain. A third name is what they call the felicific calculus. Can somebody just in 1-2 sentences tell us what this principle of utility or hedonistic calculus or principle of pleasure and pain or felicific calculus is? Abdul Karim Abdul Razak.
Yes, sir. I want to talk on the hedonistic calculus on the principle of pleasure and pain.
Please go on.
The principle actually says that if people knows that the laws provided a particular punishment for something, they will avoid the pain of the punishment and try to comply with the law. So complying with the law means that they are enjoying the pleasure of their freedom without anything that will interfere with what they're actually enjoying from obeying the law. That's my understanding about that principle.
Thank you very much. And I think that's as good as anybody can explain about the principle of hedonistic calculus. But now, what you call hedon is Greek language. And Greek language basically is there's a mythical people where that the only thing they were devoted to was pleasure. The only thing they thought was worth undertaking was to give yourself pleasure as much as you could. And they obviously, if that is your attitude, there will be excesses in terms of how you live your life, parties, food, gluttony. You overeat, overdrink, over everything, and you God forbid, we'll talk about some of those other things in this class. Now, hedon is a Greek word for excess in terms of looking for enjoyment. And calculus obviously is to calculate. So when you're looking at things where people talk about there's a pleasure principle, what hedonistic calculus means is you are calculating pleasure. And again, people call it the principle of pleasure and pain. And one of the things you have to realize is now this principle goes outside of the study of law. It is not just restricted to the study of law, it's restricted to other things. There's a principle of pleasure and pain that applies to larger theories outside of law, such as life, for example. And you can also give that principle of pleasure and pain for things as banal and as basic as training an animal. There was a time I used to have about, I think, 4 Rottweilers in my house. And I realized that you could train a Rottweiler in maybe 5-10 minutes, not to take food you don't want it to take. And what do? The principle of pleasure and pain. You put the food beside him. Each time he moves his head near the food, you move the joy away. By moving the joy away, what does it do? He feels pain. Second time you do it, he's a little reluctant because he's thinking this man is going to move my joy away and I'll feel pain and disappointment. So he hesitates. And when he hesitates, you give him the food and say, good boy. And he eats it. So he understands that there are sanctions. Sanction is the disappointment and the discomfort he feels when you push him away. And that if he follows the rules, which is, unless I say, good boy, take it, he won't take it. He will understand that if he follows the law, then there will be pleasure. And that is the general principle that this thing works with. And the idea is men are always in search, human beings are always in search for pleasure, for comfort, and they are always running away from displeasure, pain, discomfort. And that is how this principle came into being, because we are always mentally calculating what it is that gives us pleasure and what it is that gives us pain. We tilt towards things that are pleasurable and stay away from. If you see somebody on the streets now with broken legs, blood all over his body, the first thing your eyes do is to move away from that scene. Why? Because it's causing you psychological pain, even if not physical pain. Right?
Yes, sir.
Yes.
Yes,
Now,
sir.
if you see someone like me, a young gentleman, and I just I come to the faculty with a Lamborghini or one of the most expensive cars in the world, what happens to your eyes?
We are wild, sir.
We'll be happy.
We want
Thank
to
you
look
very
at
much.
it
That is not
more.
going to happen anytime soon. But I thought someone was going to lie and say, no, I won't even. Why? Because it gives you pleasure to look at something that's desirable. And basically, that is how the principle of pleasure and pain works. But what he now says is that that principle forms a yardstick for determining the advantages, benefits, or good, or the disadvantages or suffering of the individual. And what he's basically saying is, when you follow that principle, you are following that principle in terms of your relationship with the law. And if you are going to have a legal authority that says do so, and so, you can, but again, this comes from the basis. It comes from the basis of having a connection with your state and being part of a state that is functional. Now, this principle, the principle of pleasure and pain, he says, results from 4 sources. Pain can be caused by physical means, right? Pain can emanate from physical means. And he says pain can also emanate from political means, from someone who is your political superior, for example. Then pain can emanate from moral means. If, for example, you are doing something that you consider immoral, and immoral can be, moral or immoral can be judgment between the judgment of individuals, for example. There are people you will see who thinks it is immoral to cheat on his wife or to divorce his wife, but he does not think it is immoral to go to the national treasury and loot the whole place. So for someone like that, he's more likely to suffer pain from cheating on his wife than from stealing from the national treasury. So particularly for morality, we've always known that morality is your own perception of its internal to a large extent. Then there is also pain that can emanate from religion, your religious perspective of what you are supposed to do and what you are not supposed to do, which may in itself be different from a general morality that we talk about, because some of these things will be specific to things. I know that there are people, for example, who will not want. Are you hearing me?
Yes, sir.
Yes, sir.
Okay, I saw that it was saying the network was unstable. Now, there are also people, now, some of these pains, the sources of which this pleasure and pain can come from, obviously physical pain will come from here, this world. Moral pain may come from this world. Political pain will come from this world. But religious pain is something you see in terms of when you transit from this world to wherever it is you are going. And he says all these things touch on, they are all sources in terms of our relationship with the law. He says physical is the pain or pain which results from the conduct of an individual, right? Which results from the conduct of an individual without any external sanction. You have seen people who will kill someone and then start vomiting because of the revulsion at killing someone else. Political is the pleasure and pain which arises from a political sovereign or superior. Moral is the pleasure and pain which arises from the spontaneous human conduct, as opposed to some fixed standard or rules. Religion is that which arises from the hands or intervention of our concept of an invisible superior being, our understanding of a divine being. Now, while the first three are applied in this life, religious sanctions may be applied in this life or the next. Now, I took time to read out that because I think it's a very simple explanation of the sources of pleasure and pain or hedonistic calculus. And he says we are constantly calculating these things in our heads in terms of our actions, and that bears a great relationship with how we understand law and what we think the purpose of law seeks to serve. Now, also, because Bentham has defined law in relation to its object, which is what I just said now, the objective, what is the objective of law? He has been seen as helping in specifying the purpose of law rather than a definition of its nature. For this, he is sometimes referred to as both a positivist and a realist. Henry Bakewell, go on.
Sir, I want to ask a question. You know, at the initial stage, we said that during Bentham's opinion or view was that the law is whatever the legislature said it is, or whatever the legislature enacts.
Yeah.
So what is the relationship between that initial proposition and this seeing law using the objective? Do you understand my question? Like, what is the bridge between he saying that the law is whatever the legislature enacts and the principle of utility that we are discussing about?
Thank you. Now, the principle of utility is not the one of the things that we have to learn first and foremost is that when someone says law is whatever the legislature enacts, that is not the only theory he propounds. We simplify it by just stating what the person is known for. I hope you understand that.
Okay.
So there are other things,
Yes,
there are other theories. When we start talking about the what some other scholars do, you realize that somebody like Roscoe Pound is seen as both a realist and a socialist. Why? Because he was focused on what he calls social engineering. In fact, when people use the word social engineering, people don't understand that it's probably Roscoe Pound that popularized that phrase social engineering, and every politician uses it. And then he is seen as both a sociologist and a realist. But now, when you say, one of the things he says was, law is whatever the legislature enacts. Now, whatever the legislature enacts, hello? Now, whatever the legislature enacts is on its own a theory. And he says there's also something called pleasure, the principle of pleasure and pain, which is I don't know how to say it, which is a foundation for people's behavior with the law. Now, if that is a foundation for people's behavior with the law and their relationship with the law, it now means that the law can harness it in terms of its purpose. I hope you can find the linkage now. So it's because of how the law can harness these four sources of pleasure and pain for his purpose, that he's saying, that we are saying he is seen as a positivist and then also seen as a realist. I hope that is understandable.
Yes, sir, I understand.
Okay. Now, that is basically for Jeremy Bentham. Now, if you are doing a small recap of what Jeremy Bentham has said, we will say Jeremy Bentham, of course, he was British, and he was known as one of the deep thinking scholars, British scholars of his time. One of the things he focused on, like we said, was what he was best known for, as most positivists are known for, is that people should not be focused on the is, on the ought of law. And you know, when we started the class, we started from the knowledge that we said the oldest school in jurisprudence was the natural law school, right?
Yes, sir.
And a lot of these theories are a reaction to natural law theories. So when you see a lot of these, at the back of your head, you must understand that there was a theory before this called natural law theory, where they were talking about the primacy of the human reason. If a human being, there are some reasons that are embedded in us as human beings that make laws and our obedience to laws and our understanding of law almost universal, because it follows human logic and things like that. And these people are saying all that is absolute nonsense. Law must be what legislators or law-giving authorities enact. Nobody is interested in morality. The only time you should be interested in morality is if you compound it into a law source and then you enact it as a law. That is when it becomes the is of law, and then we'll learn it as the law. But until then, if we are thinking about what should be the law, it is futuristic and it's a wasted exercise. Now, for John Austin was an Austrian person with a military background who also came, and you find out that most of the theme will be similar across the jurists. He also came and he said that the focus was obviously law is what the legislature enacts, but he went further to say that there must be something called the command of the sovereign. While Jeremy Bentham was a little loose in terms of where law emanated from, and he looked at it from the perspective of, okay, a legislature, fine. This person says there must be a command of the sovereign. And because he had a military background, his understanding was that command of the sovereign must be unimpeachable, to the point where the sovereign himself does not need to answer to his own laws. I hope we understand.
Yes, sir.
Yes, sir.
You people are not sounding too enthusiastic.
Yes, sir.
Go on.
So are you going?
So I want to know, you said such that the sovereign himself, is it that he's beyond the law now?
He is beyond the
sovereign
law. He is not compelled to answer to his own laws that he has made.
Oh, okay.
And he was looking at it from the perspective of, the kings of England, the old kings of ancient Europe, who made laws in terms of commands and did not need to follow their own law. That was his perspective. Obviously, because of what he has said, there's very little mileage for John Austin's theories in present-day life, other than, of course, to study it, and which was why people thought of him as being controversial. But a lot of times, you also look at them, particularly in developing countries. His theories still work in terms of how we view law, how governments and the powers that be view laws as a command of the sovereign, almost like a rulership rather than a servantship of a servantship style of governance. I hope you understand that. So when you look in terms of what is happening across Europe now, this may be a little difficult to substantiate, but we can still do a little of that substantiation in our own continent in Africa, being a developing continent where democracy does not have all the compelling characteristics that it has in other jurisdictions. Now, he talked about command of the sovereign and what he called law properly so called. And now he's trying to understand what the nature of law is. And he says there's something called law properly so called and law improperly so called. So let's shift to a diagram I just copied off the internet this morning to help us explain that, better. Now, when he says this is the diagram, I'm going to make something like this for you to take a closer look at it. But the reason I have not put it inside your slide is because this comes straight from the internet without giving credit, and we are just using it as for studying purposes. Now, his understanding of law is this, that there are two things, law properly so called and laws improperly so called. And what he considers to be law properly so called are the laws set by God to men. So obviously there's a little understanding in his own case in terms of almost religious laws, particularly if those religious laws have been brought into force by legislatures. One of the religious law will be, for example, under the Marriage Act, the whole idea of one man being married to one woman to the exclusion of other people. Those will be laws set by God to men because it has its basis in canonical law. Now, the other will be laws set by men to men. And that will be laws basically that are just there for use, that do not have any direct relationship to any divinity. Then he says there's also something called law improperly so called. Now, for law improperly so called, there are two types of laws that are improperly so called. The first one is laws by analogy. Laws by analogy would include things like customary law, where you just do things because somebody else is doing it. And as we call customary law, for example, it becomes a mirror of acceptable usage. I think that's the phrase we use in your Nigerian legal system.
Yes, sir.
Okay. So when you talk about that, it becomes a mirror of acceptable usage. And when you say something is a mirror of acceptable usage, what it means is that you are doing it by analogy. Let me give you another example of things you do by analogy. The laws of fashion, for example, are laws by analogy, where it follows, for example, that if you are a working person, you dress formally from Monday till probably Thursday. Then by Friday, you sometimes dress casual. Those are rules of analogy. Or that if you are entering a church, you remove your cap to show respect. Or you are entering a mosque, you remove your shoes. If you are stupid enough to wear your shoes inside a mosque, I think people will just look at you like a stupid person and ignore you. So those are things that you call laws by analogy, laws, behavior that people just do to mirror each other that are not set in specific statutes. Then another thing he is laws improperly so-called. He says they are laws, but they are not properly laws. What he calls laws by metaphor. Laws by metaphor, for example, will be things that are natural laws. And I don't mean natural laws in terms of linking it with what the natural law school are saying. I mean natural laws in terms of metaphysics. I mean natural law in terms of metaphysics. Unfortunately, I'm not focusing on your charts, but I'll try and do that soon. It means laws by metaphor is number one. The law of decay is a law by metaphor. What is the law of decay? The law of decay is that if you put a living thing down and it dies, it is going to decay. That is a law. But it's not a law as envisaged by Austin. It is a law by metaphor, a natural law. Another thing is that if you are in Nigeria, obviously, the sun is going to set from the east. That is also a law by metaphor. I hope you understand. Now, for laws by analogy, he says laws by analogy are laws of positive morality, which is where customary law comes in. It means you are just mirroring another person's behavior and following it. Constitutional conventions, for example, everything according to him under chapter 2 of your constitution are laws of positive morality. Because it talks about ambition, what we want to do. The ought is what your chapter 2 talks about, until it is positivized and turned into an is. Let me give you an example. The chapter 2 talks about every Nigerian shall be this, and that. There should be no discrimination in terms of geography, in terms of regions, in terms of this, in terms of that. And because of that, there was set up a specific federal character law, having what you call, I think, the Federal Character Commission, to make sure that even in things as basic as the admission of students, there will be a federal character that is imposed. So that idea that was positive morality in chapter 2 before graduated from just being positive morality into a specific law. I hope we are getting it so far.
Yes, sir.
Yes, sir. Yes, sir.
Okay. Now, again, under laws set by men to men, he talks about laws set by men to men as political superiors or in pursuance of a right conferred in such superior
Yes, sir.
person or entity. And what that basically means is this is what he calls positive law. And this is why he's a positivist. Because the word positive law comes not from positive, negative, it comes from posit, to state, to command.
Yeah.
Then again, laws can be set by men, not as political superiors too. Now, if we go back to the last slide, we have read what he said in terms of his understanding of what the law is. And you can, if you check the internet, I'm sure you can have other, this wasn't in the original slide I gave you. But if you check the internet, you can read more in terms of his idea of what is law properly so-called and law improperly so-called. Now, some of the criticism, number one, is that his sovereign is not bound by his own command, which in modern cosmopolitan life is almost unheard of. Except, of course, your former President Donald Trump. And then he says, they said his classification of law properly so-called and law improperly so-called is whimsical. Whimsical means he just does it at his own. There isn't a structure to it that is stable. It is just whimsical, specific to him and his opinions. And he says he has excluded international law, customary law, and constitutional conventions. Now, international law he has excluded from what he calls law properly so-called. Who understands why he would do that? Why will he remove
Maybe
international law?
it's because I think it's because most international laws are treaties, conventions, agreements. They're not really laws given by a superior to an inferior.
Thank you very, very much. When I hear things like this, it makes me happy because it means that we are getting somewhere. If you can just see a particular law, now you are beginning to analyze. That is what you are doing. You know, we talked about Bloom's taxonomy, how you analyze the different stages of intelligence. Now, what you are doing is analyzing. Why? Because you see international law now and you think, okay, why will he not accept international law as law properly so-called? Then you look at his diagram, his understanding of law, and it becomes clear to you that a lot of things in international law are based on what? Diplomacy, treaties, not sanctions. There isn't an authority that says all of you must do this. People are coming together by common consent to do it. Switzerland for years was not a member of the United Nations and nobody could force it. Today it can decide it doesn't want to be a member and pull out of the United Nations and nobody can force it to join. In terms of the legal regime that's already in place in the international realm. I hope we understand. So because of that consent, it says basically, if I'm the one consenting to follow these rules and regulations, then the whole idea of a commander doesn't exist. And because of that, international law is not law properly so-called. It's a rule of positive morality. Because you can follow it or not follow it. If it's a rule of law, then it must compel. I hope we are getting this.
Yes, sir.
Yes, sir.
Okay. Then the same thing goes for customary law, obviously, because customary law, again, does not compel. A lot of times, there are no criminal. Customary law, as a matter of fact, that is one of the main problems that Jonathan has with customary law. Customary law, a lot of times, does not even have
a commander, a sovereign.
There is no commander, there is no sovereign. It's people having a mirror, what you call a mirror of acceptable usage, and just doing things in a particular manner over time. So you can't identify a sovereign. Other than the fact that you cannot identify a sovereign, you also do not have it even in a written form. Obviously, if you turn it into a written form, then it becomes legislation. Your rent and recovery laws were basically common law. But when states started having rent and recovery edicts and all that, mirroring what common law was, it became just simple legislation. Why? Because he's not looking at its basis, where his idea is that is the ought or the whatever. What we are interested in is what has become law. What is law now? And all these things you must understand is an affront. It's an objective to contradict what the natural law school scholars are doing and what their theories and postulations are. You must also always have that at the back of your mind, which is why we leave the natural law school a little late before we address it, because when we address it, you will now be able to even get even a better understanding of all the other schools. Now, again, he says constitutional conventions, because as far they are inside, constitutional conventions are sometimes written and embedded inside constitutions. But the fact that they are written and embedded inside constitutions does not make them compellable, especially in our own jurisdiction in Nigeria. In South Africa, they have a different attitude. But in most jurisdictions, they look at an incremental satisfaction. In short, a graduated, because when someone says that they are talking about idea, our idea is to give education to every Nigerian. Our idea is to give housing to every Nigerian. Our idea is to give clean water and this and that to every Nigerian. It is not compellable. That is why chapter 2 is said not to be justiciable. It is not a crime, it is not a right you can claim from the Nigerian state. And as far as that compellability is not there, John Austin sees it as law not properly so-called.
Law improperly so-called.
Law improperly so-called. Thank you. Now,
okay, my mic.
Amira, I see you're enjoying our class. Now, some of the postulations, like I told you, and don't forget, please, every line is arguable. Every idea is impeachable. Every theory is a perception of one person's thinking. And that is why we are hoping that jurisprudence will graduate your thinking to another level. Because one of the things I always say is people who refuse to, and don't let me take credit for this, I read it somewhere. People, and I repeat it all the time, people who refuse to think become slaves of other people's thoughts. Hello, it seems we had a disconnection again.
Yes, sir.
Okay.
Yes, sir.
Now, what was the last word I said? Because I think it's important that I say this. What was the last sentence?
You said every line
You
is
said every word is arguable.
Every line is arguable. Every theory is impeachable. Everything someone says to you, there's a discussion behind it. Nothing is set in stone. That is what we're trying to tell you in jurisprudence and legal theory. Now, I also said one of the things that you do for jurisprudence is, number one, you focus on theories. When you focus on theories, what it does is it graduates your thinking beyond the normal. And when it graduates your thinking beyond the normal, what that means basically is, I talked about a statement, I don't know whether you caught that or not. And I said, I read it somewhere and it's something I repeat to people all the time, which is that people who refuse to think will be slaves to other people's thoughts. Because theorization is a vacuum that everybody requires to do, because you need to evolve a philosophy that works for you. And if you evolve a philosophy that works for you, if you decide that you don't need a philosophy, then you'll be following other people's philosophy. If you see Professor Oba now, his whole life is dedicated to that. That there's nothing wrong with customary law or other types of law. There should be the importance of legal pluralism, having an understanding of philosophies across board, not just one person's philosophy. I hope we get that. Now, okay, Mujib.
Yes, sir. I didn't get the part of Professor, but is it that he has devoted his whole life to the studying of other people's philosophies, or he has his own philosophy on board as regards cultural, customary law and stuff?
Now, he has, what we're saying is, ideally, if you were just following the philosophies that are handed to you, then a lot of Professor Oba's writing will not be touching on things like customary law, Islamic law, sometimes African jurisprudence. Why? Because Western jurisprudence is already there. And if you were not thinking, for some scholars who are not thinking, they just accept Western jurisprudence as being the jurisprudence that covers everything. Which is where the whole idea of if you do not think, you'll be a slave to other people's thoughts come in. And you have to understand that there are a lot of other jurisdictions out there, which is what Professor Oba, like I said, has dedicated his life, his academic life to. That there isn't just Western ideas, that there are African ideas, there are other cultural ideas, there are Islamic ideas, and that all these form a bank of thoughts that should come together to be assessed by academics, by everybody. I hope that answers your problem, your question.
Yes, sir, it does.
Okay. Now, and that's the kind of thinking I want us all to do. Because when someone comes in and says, in Europe, for example, one of the reasons you enter the European Union is the first thing you do, one of the things you do, obviously, is there's a philosophy that says that they do not believe in the death penalty. So even if somebody were to commit a crime from a country like Nigeria and faces the death penalty and runs into Europe, because of that philosophy, Europe would not be able to extradite that person back to Nigeria so that he does not face the death penalty. And it is the same thing in the US, Europe and the US. They will not be able to extradite that person to a state in the US that practices the death penalty unless they can enter into a kind of bilateral agreement, basically that says this particular person will not be made to face the death penalty before they can now extradite the person. I hope you understand. And these things come from philosophies. So if we do not have philosophies, our way of thinking, our way of doing things in line with what our developmental aspirations are, then you'll be confused. You'll be confused in terms of whether there should be, for example, same-sex marriage or not, whether female genital mutilation is right or wrong, and all those other issues that we talk about. Take feminism, for example. I'm sure Mrs. Raji will take you through the whole gamut of feminism. When people look at Islamic law, the first thing they look at is, oh, women are wearing hijab, they must be suffering. If women are naked on the beach, for example, trying to look for the attention of men, are they not suffering? Hello?
Sir?
They are suffering, sir. Seriously.
Yeah, they are suffering in need of
It's
men.
just, you know, so it's a question of perception, how you perceive things. What is your philosophy?
Yeah, suffering. Yes.
It's, you know, what is your philosophy? What are you looking at? And you look at that, you look at women you'll be shocked at how many types of cosmetic surgeries people do in the West as against Africans don't even bother with cosmetic surgeries. So when somebody uses 20,000 pounds, for example, to just alter the nose so that the nose looks a particular manner and I can be desirable to men and I can look so and so, what are you doing?
Suffering.
But that comes from philosophies. That's where we are trying to get at. It comes from philosophies. It comes from a way of thinking, where if we do not have our own way of analyzing things and having our own postulations and our own understanding of what law is, what we want to do, what our life is, what we want to do, then we won't have these answers we are having. Because you must be able to deconstruct that philosophy and say, no, there's something wrong here. Why would polygamy be wrong and same-sex marriages is right, for example? What is the philosophy behind it? So when we go through some of these things, the whole idea is to get to a point where you're thinking, and you're thinking for yourself, not just swallowing other people's thoughts. Now, that is, now they said he states that customary law is no law because the sovereign is unidentifiable, forgetting that customary law, being a living law, emanates from the people. Its sovereign could well said to reside in the people. Something such as ostracizing is a punishment as terrible as any other punishment. And it happens a lot in customary lives, where somebody does something that is seen as taboo, and then nobody goes to him and puts a gun to his head and says, we are going to execute you. He goes to the marketplace, nobody will sell things to him. If he's selling things in the marketplace, nobody will buy. He greets people that he used to consider friends, they won't answer. He is shunned as a darkness on society. A lot of people who went through this will prefer to commit suicide rather than go through this. Is that not sanctioned?
It is.
It is.
It's a sanction worse than the death punishment, than the death sentence, you know. So a lot of this, which is why it's important to learn this, but you must always understand that you are learning it for a purpose, to evolve your own thoughts about things. Now, his idea was also that constitutional conventions, a lot of the things under chapter 2 of our constitution, nobody follows, nobody cares, which is true, it's not a lie. But when he talks about constitutional conventions being broken with impunity, the truth of the matter is that it is not just constitutional conventions that are broken with impunity. Other laws within the jurisdictions are also being broken with impunity. Not just in Nigeria, everywhere. When Donald Trump, for example, wakes up and somebody is convicted for protecting him, and as president, he wakes up and before he leaves office, he says, I pardon you because you were convicted for protecting me and refusing to give information relating to me. I pardon you. Somehow that is legal and that is okay. And we have to understand that you can use the law to break the law, because that is definitely not the intendment of the law when it says the president shall have a power of pardon. The law did not foresee that the person he is pardoning is the person who refused to snitch on him. I hope the word snitch is being used normally here now.
Yes, sort of.
Sort of. Okay, a snitch is somebody who goes and gives information about criminal activity between him and somebody else and gives it to police for whatever. It could be for monetary gains, it could be for protection from him also getting convicted and all that stuff. Okay, now the whole idea that we are trying to advance now is thinking. So if there was an exam, for example, and somebody just writes out these word for word, I think it will be a great disappointment for us, because the objective is to bring your own thinking into the discourse, to be independent in terms of how you reason. Now, some of the criticisms are these. Number one, that his idea seeks a definite commander. But in complex societies filled with balance created by separation of powers, amongst other variables, it is difficult, if not impossible, to have a specific and identifiable sovereign. And I'll explain to you why. One of the reasons is because most legislatures now, most constitutions provide for different layers of government. The first one, in Nigeria, we have a bicameral legislature, where you have the National Assembly consisting of the House of Representatives and the Senate at the national level. Then for the states, you have the state houses of assembly. And because of the constitution setting out what is in the concurrent legislative list and what is in the exclusive legislative list, some of these powers are separate and arrogated specifically to the different layers of government. There are some powers in the exclusive legislative list that is federal and nobody can touch it, apart from the National Assembly. Some are in the federal units like the states, and the federal legislature cannot touch it. And there are some that overlap. Some of those ones that overlap will probably be in the areas of the environment and all that. And it is understandable why it overlaps, because the environment is not something you can use geography to put a border on, especially when you're talking about spatial environments. Now, under those circumstances, one of the things that you see is there are two levels of government. Now, in some other countries, they have tricameral legislatures, where you can have at the federal level, you can have at the state level, then you have at the municipalities. Our own municipalities, local governments, and all that stuff, powers are derived from the state legislature. So that's different. Now, if you do all this, the exclusive legislative list alone gives authority to a particular person. It could be in the state. So because of that, you can't say categorically that there's a definite commander. But when you look at the laws, you can understand clearly that, okay, if you are still trying to hold on to this whole commander theory, then for this particular law, the commander will be the state legislature. For this other law, the commander will be the federal legislature. In another jurisdiction, it could be the taxing of local roads, for example. It could be the commander becomes the legislature of the municipality. I hope we are understanding.
Yes, sir.
So because there is no specific commander, which he didn't foresee, it becomes difficult to have a sovereign in the way that he wanted to have, that he postulated, the way of his theories. Now, again, the next one is, while the study of command may capture the essence of criminal law, it falls short in the arena of civil law. When we talk about command and we talk about sanctions and we talk about all that, he's talking primarily about criminal law. In civil law, for example, one of the things is, if somebody is a donor, in the law of gifts, if I'm a donor and I want to donate something to you, and there's a specific law as to what to do or what not to do, if I mean, in terms of getting the donation to the person, to the donee, what happens? Nobody sends me to prison. It's not a sanction, because I don't go to prison. If it's something else, for example, like the law of elections, and we talk about voting, obviously, if I go to the polling booth and I grab a ballot box and I take off, and they catch me, that goes outside the law of elections. We are talking in terms of theft and God knows whatever other laws there are. Those are criminal matters that have criminal sanctions. But if you give me a ballot box and I decide to take the back of the ballot box instead of the front with the boxes and check on the person I want to vote for, nobody sends me to jail for that. But and there are no sanctions in the statutes that state those kind of rules. Henry.
to
Hello, we can't hear you.
the law states how to make wills.
I think you are off. Let me continue. Then give us like about 5 minutes. Then you try to ask again. I think there may be an issue with your network. So, and then he is smart in terms of some of the things he says. Because when people now say, when you talk about command, what do you mean by command? If I talk to my children, am I not commanding them? Am I not a sovereign? And he says, number one, you are not a political sovereign or a political superior. What you are is that what you are doing is that you are issuing, there are general commands and then there are particular commands. General commands you issue to a group of people. And that is what can be termed as law. But particular commands are issued in terms of personal relationships, and they are not general commands. Take, for example, a command from myself to my children, a command from the lecturer to his students. What the sovereign does is to give general commands. And what small people like me do is to give particular commands, which cannot be seen as law. But basically, you must also understand that in medieval Europe, for example, most of the laws that turned to general commands were sometimes particular commands that graduated into general commands. Abdul Karim.
All right, sir. I actually want to ask in terms of civil law. You said since there is no issue of command in civil law, the definition given by Austin is actually not fitting to civil law. And I want to ask, in case of the like Tortures Act, where there is duty of care being imposed on other people to ensure that they protect their neighbors and ensure that any act they are doing does not affect the next person who is actually near to them. That principle, duty of law, can we say it is a command under civil law too? Or it means definition does not apply to civil law generally?
I would exclude anything that does not have, whether it's civil law or not civil law, I will exclude anything that does not have punitive measures, punishment, sanctions. I hope we understand.
Yes, sir. Yes.
If you have a duty, and when we're talking about civil law, we were basically talking in terms of things like the law of contract and things like that, which basically will be within understanding of civil law. And then also other things that are not criminal in nature. And then that does not have sanctions attached to it. If it's just a question of, say, it's an administrative problem, it becomes voidable or it is void if you do not sign this agreement in a, of course, another argument could be that your punishment is the void, is making that document void.
Exactly.
So we can have that discussion that if the document becomes void, then that is a punishment in itself. But I can tell you that that is not the punishment that John Austin had in mind. What he had in mind was in terms of prison sentences, fines, sanctions that are specific, not sanctions that are psychological. And when we talk about sanctions, now what that does basically is, if I wrote at the back of my ballot paper the wrong thing, and I realized that I wrote at the back of my ballot paper the wrong thing, I can go back and beg them that I want to retrace that ballot paper before they push it inside the ballot box, that I made a mistake. And I don't know if you understand. If they can trace it, they'll give it back to me to do the proper thing. It's the same thing with wills. If I write a wrong will now that may not be legal, I go back and I write another will and I say all testamentary depositions, this and that by me have been overtaken by this present will that I'm doing. So because of that, it goes outside of John Austin's contemplation. I hope we understand. So if there's no specific sanction, even things that are avoidable can be righted and all that stuff. That was not his thinking. And the next one, I just want us to go through Hans Kelson before we finish so that we can say, okay, we've done the Positivist School. Go on, any question, Abdurrahim? Okay, let's go with, let's continue. Now, Hans Kelson was another scholar. And for me particularly, my understanding of Hans Kelson was that of a brilliant Austrian jurist who had a great understanding of the idea of a system of norms. What is a system of norms? Norms is a standard of behavior or conduct, right? And he's saying it's a system. It's not that one thing. It's like a spider web of interconnected systems of norms. And he said there is something called the pure theory of law, which is, of course, it goes to what the other two scholars were saying, which is don't bother yourself with the art of law, focus on the ease of law. And the way he says it is that law was a self-sustaining phenomenon, that law can sustain itself. It doesn't need the understanding of metaphysics, of biology, of medicine, of any other thing, that it is self-sustaining. And because of that, the theory itself, the law theory was pure. And it was separated from metaphysics, politics, sociology, and all that. But again, the key thing, as with all positivists, is that it is a challenge to natural theories of law. Now, we are going to go through the basic premise upon which he has his own theories so that we can understand what he was saying. He said, according to him, the purpose of law was to reduce tension and conflict. Now, when we talk about reducing tension and conflict, you will see some of that again in sociological scholars' rendering of what they think the purpose of law is meant to be. Now, and that legal theory was a science and was the knowledge of law. Legal theory is a science and it is the knowledge of law and not what it ought to be. Again, you can see the similarity between the two previous people that we have learned, because those are the constants. Those things are constant if you want to talk about the positive law school. And that it was a normative and not a natural science. It's a science that talks about how behavior is enforced, not something that talks about natural logic. I'm paraphrasing so that we can understand it easier. It was a natural science, and that the purpose of law, being a theory of norms, was not its effectiveness. It's a theory of norms. It compels behavior. The theory should not be focused on whether that compellability is effective or not. It should be that in the form that it is, it comes from the right authority and that it compels behavior. That legal theory was formal and was a way of ordering specific consequences in a specific way. Do this. If you do not do this, this will happen. And that is what legal theory should be focused on. That the theory of law in relation to a particular system of positive law is that of possible to actual law. And I said, what he's saying now is that the theory of law in relation to any particular system that is having positive law is that of every other thing that you talk about should lead to what the actual law is. So all the ought is this, the that, if you are looking at it, you have to be very clear in your head that you're studying, what you are studying is not law, it is rather sociology. You are studying something as something that is going to lead to actual law, not what the law is. I hope we understand that.
Yes, sir.
Okay. Now, there are a couple of things I'll tell you about Hans Kelson. You know, we're talking about having spider web of this, and that. And what he said basically was that there was a law exists in a pure theory. And that in that pure theory, everything that you can call law has an interconnectivity with other laws. And he talks about this hierarchical structure of laws. Number one, the mega law is the Constitution. The mega law says what other laws should and should not do and the places of those laws. In Nigeria, any law that is inconsistent with the provisions of the Constitution is null and void. Right? But again, we talked about our exclusive legislative list and what's the other one? Exclusive legislative list and the concurrent legislative list.
Concurrent.
Thank you. Now, when we talk about these two things, one of the things that it tells us is that there's a hierarchy. While we may have a bicameral law or whatever legislature that divides that hierarchy, what it tells us is that the biggest of the hierarchies is what he calls the grand norm, which essentially is the Constitution. Now, when you talk about the grand norm, which is essentially the Constitution, you come to other things. If, for example, we have the Environmental Protection Act, you can link the Environmental Protection Act to the basic Constitution. It gets its power from that. Every law gets its power from another law, which may get its power from yet another law. If you talk about, if the Minister for Environment or whatever, I'm not even sure there's a Minister for Environment. Now, if he makes a law and he comes with regulations, those regulations will emanate from the statute that deals with the environment. If the CBN governor, for example, makes regulations about something like, let's say, agent banking, how you can be using POS machines and all that, then he's making that law against the background of the CBN Act, which emanates from the legislature's power to make law over banking, which is in the Constitution, which says basically that they can make laws relating to blah, blah, blah. I hope you understand. So every law has a linkage to another law. And in trying to find out the legitimacy of laws, what he now said was, and then people asked him a question, which was, if all this leads to the 1999 Constitution in Nigeria, for example, what about the 1979 Constitution? Or the 1966 or 1963 or 1960 Constitution? All these other constitutions, what is their place? And their place was, because he said law was a pure theory of law. Law was a self-sustaining phenomenon, but he added a rider, which was that the original validation for law will come from a non-law source. The original validation for law will come from a non-law source. And for someone, which was a little of a contradiction for people, because they thought this person is talking about the pure theory of law. And he's saying the original validation for laws will come from a non-law source. It was a criticism, but it wasn't a criticism that was grounded upon anything that I consider serious. You can have a different opinion. And what he said was, if you have a constitution and through legislative acts, there's an amendment to that constitution, then a new constitution comes in, then you follow the trend of that constitution. And the question was also asked that, okay, then who are the people that are this non-law source? And some scholars answered in respect of, okay, it could be the non-law source could be the people. Now, and he says, if the non-law, the original constitution and the non-law source is the people. Take, for example, in Britain, for example, the first Canadian constitution was actually enacted by Britain. So are you saying the original people are British people and that is the law that Canadians are still following? Now, this discussion I'm telling you, I had it with my brother, who is also is a lecturer at the University of Abuja, and we had this discussion. And he kept scratching his head, and a week later, he came with something he thought was an idea as to how to resolve that problem in his own mind. And he spoke to me about it. And I didn't understand what he was saying. And he said, okay, he's going to write a paper. Maybe if I read the paper, I will understand what he's saying. He wrote a paper, sent the paper to me for reviewing. I still did not understand what he was saying. He now sent it to a journal, Commonwealth Law Bulletin. And the editor of that journal was so enthusiastic about the paper that sometimes at 2 a.m., they will be exchanging emails about the paper. So obviously, these two people understood what they were saying, and your lecturer in University of London did not understand it. After continuous reading and all that, eventually, what my brother's main premise was that, and what he wrote in respect of Hans Kelson, and he did that in respect of developing nations, how developing nations can find self-actualization from Hans Kelson's idea of the original norm, of the original, the original rule, the non-law source that we are talking about. And he said that the non-law source, in fact, can be found in the Constitution. Hello, I'm sorry. Apparently, I went off again. So I'm just going to round up now. And what my brother said was that the non-law source can be found within the Constitution. And I said, where do you find it within the Constitution? And he said, in the preamble. And he wrote this large thesis on why the preamble is not part of the Constitution, for him to be able to justify why the preamble is the non-law source that was being talked about. And he said the preamble is not part of the Constitution. The reason the preamble is not part of the Constitution is because it is not directive, it is not compelling, it is not a sanction, it is not, it does nothing that the Constitution does. What the preamble does is just to say, we the people have come together to raise up this Constitution. And that if that is what they were doing, then it means right from the original Constitution, where you have a preamble that says we the people, the next Constitution that has another preamble cancels the last preamble. The next one cancels the previous preamble. The next one cancels the previous preamble. So at all times, it is we the people. And that because again, the preamble was not directive or a compelling part of the Constitution. It is encased in the Constitution to find the source of the norm, of the ground norm. And in this simple language, it became much easier to understand what he was saying. But now the point I'm making is all of us must strive to think. Because once that starts, then you can have an understanding of jurisprudence that will help your society, not just you. It will obviously help you, but it will also help your society in the way we situate our laws and the way lawmaking processes are done. And each time when you become lawyers, each time any state is having a law review function, a law review committee, a law review, whatever, the first people they are looking for are people that, the first people they should be looking for are people that understand jurisprudence. Any questions or comments?
Yeah, good morning, sir.
Good morning, how are you?
Fine, sir. So just I just want to be sure of something. When you were talking about Jeremy Bentham, so and his theory about positivism, so I want to get it right. His idea of the law as what the legislature says is talking about the process of what actually makes a law the law, and then when it talks about pleasure or pain, is actually what the reaction of the people are to the law. Am I right, sir?
Yeah, right. Yes.
Okay, sir. Thank you.
Okay, that was relatively painless. Anybody else? Mujib Aziz.
Yes, sir. I dropped. I asked a question in the chat about who is responsible. Do these thinkers on the law, do they consciously subscribe to some essential beliefs in some school of thought, or it is the assessors, the duty of the assessors to pigeonhole them to these schools of thought and give them names as positivists, natural law thinkers, and stuff like that? Why I'm asking this question particularly?
Sorry, what was the question before you go on? I didn't get that.
HLA Hart, Jeremy Bentham, John Austin, all these people that we say they represent the positive law, positivist school. Now, do they consciously fix themselves to these schools by subscribing to the beliefs based on the writings that some people have based on the words of some people in the past, or it is the work of the assessors in the law to pigeonhole them into these schools that, oh, this is a positivist from his style of writing, is a positivist, this is a natural law thinker? Why I'm asking this question more particularly is because in recent times, at least by the work of John Finnis, he gave a restatement of the natural law such that he condemned those who came after Thomas Aquinas and Aristotle and said that what their perception about natural law, or what natural law stood for, was very wrong. Now, more constructively, HLA Hart gave the minimum content theory for the positive law. And these are some mixtures that would never have been possible during the time of Jeremy Bentham or John Austin, or more progressively. Now, with the way things are running, and you've said at one time that, most respectfully, that sometimes these speculative thinkers, they they can be seen as going from one school to another. But the mixture of natural law with positive law, or the positivist school, as can be seen from John Finney's restatement of the natural law theory and HLA Hart's minimum content theory. So what do we say about these variations? And who is responsible for the pigeonholing and nomenclature? Should we disregard the nomenclature, a more direct finding on the theories of these foremost thinkers? More direct findings as in we trying to discover what they have written and trying to understand it, instead of listening to the opinions of assessors the pigeonholing of assessors on which schools they belong to? And then what is the fate of those who give a misstatement or a statement that creates another chaos in the law, like John Finis has done? Thank you very much, sir.
Thank you. I'm going to try. The reason I said I'm going to try is because you gave me a mouthful and I'm thinking about it and having a headache already. But I'm going to try to answer. Now, when you ask who gives a misstatement, who says who and what theory should be pigeonholed, there are two ways that happens. Number one, you are going to have people who specifically say, I am. There are a lot of feminist scholars, scholars who will say, I'm a feminist jurist. But it's not just because you say it, it is because of the theories and the alignment of your theories with the main theme running through feminist jurisprudence. HLA had basically is seen as a positivist because of his theories running through positivism. Now you can have evolutions. Now, one of the students of one of the people that worked with HLA had is somebody called Joseph Raz. And he evolved the whole idea of what you called positivist theories. And he said what you call the command was not a direct, his attitude, his idea, one of his ideas was this whole idea of laws are not effective. That if legislation is not effective, which is one of the arguments I was having, is that if legislations are not effective and customary law, for example, is effective, how is legislation law and customary law is not? Now, somebody like Joseph Raz came in and said, the misconception was that people were thinking in terms of legislation addressing citizens. That legislation was not addressing citizens. Legislation was addressing government officials. The policeman, the judge, the people in the judicial system. That it was to them an order to say, if somebody steals, what does the police do? You arrest him and investigate. You take him to the, whatever it is, you take him to the attorney general or whoever takes the person to court. That was the compelling aspect of it. Now, the whole idea of whether citizens obey those laws or they do not obey those laws goes to no issue. Now, this was not just an evolution. This was the modernization of the whole idea that we have started looking at traditional positivists. We started looking at this, an evolution of the idea of what we see traditional positivism as representing. So there are two ways around it in terms of who pigeonholes who. People are pigeonholed by their writings and ideas. And also people are pigeonholed by assessors who read what you have written. There are times people can go beyond that. Now for critical legal studies, and I'll tell you some of the things, the critical legal studies movement actually started from the University of Wisconsin in the US. And they started with this idea, their own idea, the scholars that came together, their idea was, for the critical legal studies movement, what we had was, their postulation was that if you look at every law closely, every law is set, almost every law is basically set up to protect certain rights in society. And those are essentially the rights of the people that are at the apex political and economic block of the society. If you have a law, and those are laws that we all think protects all of us, but they say, no, it doesn't protect all of us. It protects the people that are at certain statuses in the society. If you say somebody, there's a law of theft, which you think is normal, yes, there should be protection. But if there's a law of theft, who does it protect? The people that have things that can be stolen. I hope we are getting somewhere. So now for those people, it's not a question of pigeonholing. They came together as a group and said, this is the theory we are expounding on. So you can have a lot of, you can have people later come in and say, no, this is a misconception. This is not what the person was talking about. I told you about my brother who used the word preamble to solve one problem that he thought Hans Kelson was having. And that goes across all boards. So what you do as a person is, like we said, there is no yes or no answer in jurisprudence. What you can do is to come out and say, I do not believe this is what this person was propagating or postulating. There is a misunderstanding relating to what he is trying to do. And we must never lose sight of the fact that that discourse is the reason we are here. There isn't a yes or no, there's no finality to anything. I hope that answers your question. If not fully, then in part.
Yes, sir. Yes, sir. Another, sir, with due respect to my colleagues, can I proceed, sir?
Please do.
Yes, the critical legal studies movement. Can we term it as a school of thought, properly so called?
Well, because a lot of people will say it's not. Yes. A lot of people will say it's not a school of thought in itself, because like the realist school too, they come under the same criticism that they are piggybacking on other, you know how you piggyback, somebody is going there and you climb the back, that they are piggybacking on other schools of thought, that they don't have specific theories by themselves. They are just denouncing theories of other schools and then evolving so-called theories on that basis. And to a large extent, it is true. But again, you could say the same thing about people who are following the racist theory. Okay? There are some that follow the racist theory that everything is geared towards the advantage of one race against the other. And that came from some Black scholars, particularly in the US, when this thinking was, when there was this influx of ideological thinking. So why sometimes you may not be able to, but I call them a school. And the reason I call them a school or a movement is because they came with something specific. And anybody that comes with something specific, and it is not just one person that is saying it, you have a group of scholars saying it, even though they may differ in one or two things. Then for me, that's a movement. And the most obvious thing that the critical legal scholars are saying is law serves the interest of certain cliques in the society.
Understood, sir. Understood, sir. So the answers I've been able to get now, I just want to say them again so that I don't suffer some misconception. From the first question, the answer was that consciously some thinkers in the law, they fix themselves to some particular schools of thought, while it is the duty of some assessors in some parts to also pigeonhole based on the writings of these people and give them names according to the school they belong, sir. And on the second one, you hold that the critical legal studies movement is a school of thought, and you've given us the argument against being a school of thought. Thank you very much, sir. If that's the answer, sir, so that I don't suffer some misconception.
No problem. In fact, I was thinking you were laying down a trap for me somewhere by when you have said all this and I have nodded, then you now follow up with a question that will kill me. So I'm very happy to see that you are just trying to recap.
I'm just trying to recap, sir.
Thank you. Any other person? I see Bashira trying to say something. Hello?
No, sir.
Okay. Prof. Prof. Help us, sir.
This is a very interesting dimension. And I think I largely agree. with your views on the question raised by Mujib, I guess. For me, maybe for clarity, in my view, and we have always said there is no right, no wrong answer. I think labeling was a later day thing. The thinkers were just coming up with their own views, their ideas on these issues. The subsequent scholars now felt, oh, A, B, C should be in one group, D, E, F should be in another group. And that's why it is possible to find a view as positivist or naturalist, depending on who is actually doing the assessment. And even later day scholars like us, who are students of jurisprudence, who still assess some of these theorists from an entirely different perspective, depending on the development that we presently see in our jurisprudence. And that is why, whilst you agree with some up to a point, talking about pure theory of law, can we, in good conscience, be looking at any theory of law, quote unquote, as pure in this age and in this time, given the dynamics in our society? That's just the dimension I intend to add.
Thank you very much, sir. Thank you. I hope we all understand that.
Yes, sir.
Okay. And I think basically when, as times go on, because particularly for Nigerian writings, we've not seen that pigeonholing that is ongoing. But I guarantee that in some years down the line, an analysis of the judgments of people like Justice Oputa, Justice Karibi White, and things like that, Nigerian scholars are going to start looking at African jurists and African ideas in terms of how judgments come into being. What were the kinds of interpretations that these people were focused on? Was it liberal? Was it purposive? Was it contextual? Was it textual? This and that. Now, scholars like you are going to be doing those writings in future. And then eventually you will see a student who will say, did Justice Oputa call himself an Africanist? Or did he have an African theory? You understand? But that writing is going to focus on certain things that are central, a central thing that runs through the ideas of some of these jurists. I hope we are okay now.
That's true, yes, sir.
Yes, sir.
Okay, so let's round up. What we're going to do for our next lecture, we'll try and do a little recap of what we have done for this lecture to set the tone for the next lecture, which is basically going to be focused on historical school. But other than the historical school, one aspect of the historical school I want you to do some reading on is codification of customary laws. You look at the scholars, what is the main theme running through historical school, how did it come into being, what they see as the nature of law, then codification of customary law, which is something that we are still having discussions about in our own jurisdiction. So have a nice day, and my regards to you. Fantastic weekend.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you.